Many people think that having a will or estate plan is just focused on what happens to your stuff when you die. And that is an important component, but these days, a major aspect of estate planning is not just about your stuff, but what about you? What happens to you if you become incapacitated or disabled? Who's going to make medical decisions for you? What are your healthcare wishes? Does your family know what to do when the time comes? So today I'm going to talk about the important healthcare documents you want to have as part of your estate plan. The first document is a healthcare power of attorney. This is a document where you say, if I ever am in a situation where I can't make my own healthcare medical decisions, here's my agent that will step in my shoes and they're going to make decisions for me. Usually this is a spouse or a close family member or friend that we're going to appoint in this position. And we always recommend that you name one or more backups in case your first choice isn't available when the time comes. Now, the trade-off with this document is it's very broad. It says this person can step in your shoes and they can make just about any healthcare or medical decision that needs to be made, but it doesn't actually give any input from you about what your healthcare wishes are. So in our office, we call it the God power because it gives them the authority to make major end of life or death type of decisions without any input from you about what your actual wishes are. So that brings us to the second document that we recommend, which is a living will. Now, a living will is meant to be describing how you want to be cared for while you're living, which is why it's called a living will. But for most people, it's really thought of as the pull the plug document because it's usually specifying treatments you do or do not want in an end of life situation. Now, the problem we tend to see with a living will is a lot of people have really generic living wills and they don't really add anything more to the conversation because the healthcare power of attorney already authorizes your agent to make those decisions. So if you're going to set up a living will, then we recommend that it be more detailed. It should really take you through some different scenarios and different treatment options and provide your agent with some guidance about what sort of treatment you do or do not want. For example, we find when we dig into these issues with our clients, often people don't want really invasive end-of-life decisions that are just going to needlessly prolong their life, but they may want comfort measures in certain situations. So we want to make sure we know what those wishes are and we have them documented for your agent. Now, I wish we could just stop there, but in today's modern world of medicine, that's not always enough. We're living longer than ever, but the trade-off is that most of us later in life will have some sort of debilitating illness, physical impairments, or cognitive impairments. So it's not enough to just talk about what we want in our very end of life. Most of the time, your healthcare agent is going to have to deal with other issues. So we want to give them some additional guidance about other healthcare and medical wishes that might be important to you, whether it's things like your feelings on alternative or experimental medicine, chemotherapy, right to die laws, long-term care scenarios, and where you would want to reside if you need long-term care. All of those are really important things to think about and make sure that your family has some guidance so that they're not left second guessing themselves about those decisions. That can be a heavy burden for them to carry going forward. And lastly is having a HIPAA authorization. HIPAA are federal privacy laws that prohibit healthcare providers from sharing your private medical information with other individuals. This includes prohibiting them from sharing it with your spouse or family members. So we want to make sure that down the road, if you do have a health event, your family members aren't going to run into the silent treatment because of HIPAA. So with a HIPAA authorization, you want to make sure that you have your own general authorization. Usually what people ask us when we bring this up is they say, well, I signed a HIPAA authorization at my doctor's office. Isn't that sufficient? And it's really not. Those authorizations that you sign at the doctor's office is just for that doctor, and often they have an expiration date in them. So you need a general authorization that says, if I'm incapacitated, here are the individuals that can communicate with my healthcare providers about what's going on. Now, if this all sounds like a lot, don't panic. The good news is that we've made it really easy for you to take care of this. We know that most people, if we put a blank sheet of paper in front of them and said, write a letter to your family about what your wishes are, most people wouldn't know where to start. So we've taken the work out of it. We've developed tools that help you walk through different scenarios and really think through step by step what your wishes would be under different circumstances. So you don't have to worry about a thing. We'll just guide you through the tools. So if you need help putting clear healthcare directives in place for your family, give our office a call and we'll help you get started.